Now, an amendment to the Compensation for Occupational Injuries and Diseases Act now allows, this is very important, now allows for domestic workers, including chauffeurs and gardeners, to claim from the compensation fund if they are injured or contract a disease while they're at work. A very important second part to this is that they can claim as far back as 1994, and that's where the complication is going to come in. Employers being encouraged to register their domestic workers with the compensation fund. Let's find out how this amendment is now being brought in and how it's all going to affect employers and employees. The fund's acting commissioner, Farzana Fakir, making time this morning. Hello, Farzana. Good to have you on eNCA. First of all, let's just talk about why this amendment is going to make such a big difference. We'll get to the minutiae and the mechanics in a moment. Good morning.
Good morning, Gareth. Good morning to your viewers. Thank you for having me.
Only a pleasure. So I want to get a sense and contextualize, because if we're talking about dating back to 1994, why do you think this has only come in now, and what's your view of this coming into play?
So in terms of the 1994 one, let me first give you a background. Within the definition of employees in the the previous act, the amendments that were not in place, domestic workers, etc., were not included. And in 2014, the compensation fund, which is an entity of the Department of Labor and under the Minister of Labor, then embarked on a process where they started having imbizos, etc., with domestic workers to start looking at entrenching their rights within the COIDA Act and allowing them to have entitlement to benefits. But before, obviously, as you know, putting amendments into place is quite a long process, and it was just not looking at domestic workers, but it was also looking at other aspects of the Act that we wanted to improve on to give access and benefits easily to injured workers. And as we were embarking on this process in 2018, obviously, we were taken to the Constitutional Court by the Domestic Workers Association. We did not oppose that taking of this compensation fund to court, and the Constitutional Court ruled that in 2018 that it was unconstitutional, thereby supporting our notion of inclusion of domestic workers within the Act, to be for domestic workers to be excluded. And they also ruled that it was a Constitutional Court ruling that the claims would go back to 1994, but obviously within the prescripts of lodging a claim within the compensation fund. So I think you are correct. There is going to be some challenges as such in terms of employers now providing the documents, the medical reports, etc., accessing all of those when you want a claim, especially since if they from 1994 until, I mean, you're anticipating until recent, but what we are doing also is we are doing a lot of communication drives to stakeholders, and both employers and the domestic workers. We're working closely with the Domestic Worker Association to also educate them on what that process is.
Yeah, I can see one of the big questions, Farzana. Sorry, I don't want to get too caught up in the legalities of it, because I'm sure with that communication you're talking about, it will be in there. I just want to get a sense for those watching this morning. It could be employees, could be employers. When we're talking about anything when it comes to domestic employment, there's always this ongoing battle between full-time employment or part-time employment. Now we start talking about hours per week as well. I think let's just try and set everyone's mind at ease. What does this fund cover when it comes to the number of hours worked, full-time versus part-time? What are we talking about?
We will cover both full-time or part-time. So every employer is required to register with the fund. I mean, I think with the UIF, it's the minute it's over 48 hours of work per week, etc. So we also have a similar, but I mean, if you have a domestic worker, please go onto the Compensation Fund website. We've already developed the system so that you can lodge your declarations as a domestic employer, and you can put in all the details of your domestic worker. And because the access rate that any injury, whether it's part-time, full-time, etc., if it's incurred at work, it will be covered.
And just as I close off as well with you, and we're going to send people to the website to go and make sure that everyone is registered and doing what they're supposed to do as well. I also imagine then, and you alluded to this earlier, Farzana, if this is going back to 1994 and you were saying there could be some problems around record keeping and document keeping, what happens with an employer if they don't have records of someone who's been with them a long time from all those years ago? Say they only got onto contracts and started doing it properly in the last few years. What happens to all the years before? What's the sort of process for them?
So I think with the employers, it's more an affidavit in terms of records, just to state and confirm in the employer's report that they were in their employment, etc. I think the most of the challenge will maybe be the medical reports, but we are looking into processes of how to facilitate those claims and access them, and maybe also inform employers what is the best way to go about that.